My name is Ron Drescher. I'm an attorney practicing bankruptcy and commercial litigation in Maryland, Delaware, Pennsylvania, and Virginia. And today I want to explain why, if you can't qualify for Chapter 7 or 13, you can still get bankruptcy relief under Chapter 11. Under the Bankruptcy Code, you have a means test. And under the means test, that will decide if you qualify or not for Chapter 7 of the Bankruptcy Code. If your income is too high, you don't have sufficient deductions, you're probably going to be forced out of Chapter 7. Then the next question is, can I file for Chapter 13? Chapter 13 has debt limits. These debt limits, they fluctuate from year to year based upon cost of living, but they are set by statute and they are rigidly followed. So if you don't qualify under the debt limits for Chapter 13 and your gross income is too high for Chapter 7, you won't necessarily be deprived of relief under the bankruptcy laws because you might qualify for Chapter 11. Chapter 11 is a procedure for businesses, but also for high-income individuals who have a fairly sophisticated financial situation. Chapter 11 tends to be more expensive than the other chapters because under Chapter 7 there's a lot of competitive pressure in the market to keep fees down. And in Chapter 13, the fees that you're allowed to charge if you're an attorney are usually set by local rule. But there are no such controls for fees in Chapter 11, and most attorneys will charge you an hourly rate with a retainer. That's a big negative for Chapter 11. Another negative about Chapter 11 is that you're going to have to get your creditors to vote to accept your plan. That's not the easiest thing to do, especially because many creditors, especially if they're credit card companies, don't bother to vote for Chapter 11 plans because they're really not set up for it. They're much more set up to handle Chapter 7 and Chapter 13 cases. In Chapter 13, if your plan satisfies the statutory requirements, you will be able to qualify and confirm that Chapter 13 plan. In Chapter 11, you're going to have to get the votes of your unsecured creditors. But there are a lot of positives in Chapter 11 too. One of the positives in Chapter 11 is that you have a lot more flexibility about the kind of treatment that you can give to your secured creditors and your unsecured creditors. You don't have to start making payments to a Chapter 13 trustee within 30 days like you do under Chapter 13. And there are a lot of different ways that you can restructure unsecured and secured debt in Chapter 11, as long as the debt is not secured by your primary residence. Another advantage to Chapter 11 is that you can frequently stay there longer without having to come up with a plan. In Chapter 13, the trustee and usually the local practices are really trying to move cases along. Chapter 11, you have a lot more flexibility. My name is Ron Drescher. I'm an attorney practicing bankruptcy and commercial litigation. And if you have a question about the Chapter 11 process for an individual, please pick up the phone and call. I would love to hear from you.